Welcome back. Throughout the night, we've been focusing on today's very important Constitutional Court judgment. And of course, it comes just 2 days after the Constitutional Court found that former President Jacob Zuma was guilty of contempt of court and sent him to jail. He has 5 days to hand himself over. And we're watching the situation in Nkandla. We'll bring you that a little bit later. But now a legal expert says that former President Zuma's sentence is a triumph for the rule of law, but the dissenting judgment given will provide ammunition for his supporters. Omphemetse Sibanda is Professor of Law and the Executive Dean of the Faculty of Management and Law at the University of Limpopo. He joins us now after writing that opinion piece. Professor, thank you for being with us. Can you summarize? You say this is good in law, but because it wasn't unanimous, there were 2 dissenting judges, that could stir up a hornet's nest.
Thank you for having me. Yes, indeed, this is one of the good or the best judgment to come out of the Constitutional Court, particularly in this line or series of issues around the former President Jacob Zuma. But then when you consider the minority judgment, even the merits or the explication of Justice Theron and as against the majority judgment, you'll immediately realize that, in fact, immediately after the judgment was pronounced, there was already, a statement by the spokesperson of the Zuma Foundation, Mr. Mzwandile Manyi, indicating that, in fact, the majority has been sort of negligent in not listening to the minority judgment, particularly honing into that aspect of the minority judgment that seeks to say that, in fact, not only was the majority judgment a bad judgment, but then it was, in fact, an unconstitutional judgment. And that in itself has created, in my view, sort of an ammunition, or that minority judgment is now weaponized against the majority judgment, also against the judgment itself. But then there's nothing wrong in having dissenting and the majority judgment in any case.
Yeah, I mean, that's the way the court functions. And I guess it highlights how independent the judges are allowed to be in their thinking. But like you say, many people won't see it like that.
Yeah, no, many people won't say it like this. I just want to move a little bit really back to the 2 judgment itself. Really. If you read the entire judgment, you see a very detailed, well-thought judgment, both for the minority and the majority. In fact, you would even think that the justice, that is the acting Chief Justice Kampepe, is now schooling the minority judges or judgment in terms of the proper application of the law. Of course, like I've said in that particular article, in fact, I was expecting a conditional sentence that is basically the same sentence that the minority or the dissenting judgment was hoping for. But then the argument or the reasons for that, I do not really agree with it. You look at the judgment by Theron. Theron uses one particular statement from the United States Supreme Court case of 1904. And that particular case dealt with to read that U.S. judgment in context to arrive to a decision that this South African judgment is bad in law.
All right, we lost some of what you were saying there, Professor. Let me just outline.
I was losing.
Yeah.
Can you hear me now?
Yes, we can, but we lost some of what you were saying, and you were highlighting the difference that the majority said he had to go basically straight to jail. The minority said that a suspended sentence would have been better. Then maybe he would have had a chance to go back to the Zondo Commission and present himself. The majority said that was futile. It was naive to think that he would ever go back. Just tell us what you're saying in that regard. Yes.
No, I was about to say that now. Yes, in fact, my view before the judgment was always aligned to the minority judgment. That, in view of the recent extension of the Zondo Commission's lifespan, I would have expected that now the judgment will sort of say, you do have the former president, and then we expect expect a lot to come from the former president in order to explain to us, to put things into context with regard to the state capture issues. But then this judgment, the majority judgment, majority judgment, on the face of it, closes that loop. But then in fact, it does not close that loop, because the former president can still be called from the jail halls to come and testify before the commission. But then I don't think the commission really has got that appetite to go that particular way. In fact, as the Judge Kampepe said, in fact, this is going to be a futile exercise. But then my view with regard to the minority judgment, it is firstly because there is a lot of misunderstanding of how minority and majority judgment operates in the South African legal system and across all the systems in the world. But then secondly, I tend to align with the merits or the rationale for the judgment by the majority, because then there you are convinced as to why the majority arrived at a particular decision that now this is a contempt, this is a sentence. But then when you look at the minority is saying that let it be a conditional imprisonment. But then the question is, what then happens if the former president was given conditional imprisonment, but then still insists on defying the very same imprisonment term or sentence that the dissenting judgment is basically in favor of, and then he gets arrested or sent to jail? Well, then they say that in fact, what we proposed initially itself, it is still unconstitutional. That is why Justice Kampepe was very clear that there is a great contradiction between what the dissenting judgment is saying and what it is saying that we shouldn't have done as the minority, because then they see unconstitutionality in the majority judgment, but then it does not explain why the minority will not be unconstitutional if it is going to be followed by the application of the condition that if you do not go to the Zondo Commission, then a prison term or that hanging sword will then apply. So that is that part. But I think
okay, so Professor, we've run out of time, but I think you've given us an extent of how they are talking to one another, these judges in the minority and majority. Basically, their Professor of Omphemetse Sibanda is saying that what could happen here is that this was a great judgment in law. He has some criticism of the court, but a great judgment in law, but it could be used as ammunition, the minority judgment, by the supporters of the former president. Thank you very much for your time there, Professor.
Thank you.